What is a security deposit? If you're a renter in West Virginia, you've probably come across security deposits. A security deposit is any refundable deposit of money paid by a tenant to a landlord. It is designed to cover the cost of potential damage to the unit made by the tenant, as well as unpaid rent. Your security deposit is not your last month's rent. It's a separate pool of money. The tenant has to pay for any damages to the unit beyond reasonable wear and tear. The security deposit is where the landlord will start paying for this. What is reasonable wear and tear? A tenant has a responsibility to return the unit in the same condition as when he moved in. Your landlord cannot charge you for normal wear and tear that happens while you're in the unit. This includes things like a worn carpet, chipped paint, or worn finish on a wood floor. Damages beyond normal wear and tear include things like your kid's crayon art on the walls, broken windows, holes in the walls, leaving trash or other items that have to be thrown away. It's important to document the condition of the unit when you move in and when you move out. Do a walkthrough of the unit with the landlord and take a video of any repair issues, and take a video when you leave. Does my landlord have to return my security deposit to me when I move out? If you broke the lease by moving out early, or left owing rent, or caused damage to the property beyond reasonable wear and tear, you may not get a refund. The landlord may be able to take some or all of your deposit to cover any of these things. West Virginia's security deposit law sets specific time limit for the landlord to refund your deposit in full or give you a written statement identifying what is being taken out of your deposit and why. If the landlord does not meet the deadline to do one of these things, you may be able to sue for your deposit refund plus damages equal to 1.5 times the amount wrongfully withheld. If the landlord is taking money out of my deposit, what has to be in the letter I get? The landlord has to provide a written itemization of any damages or charges within a time limit. That means the landlord has to identify each and every item of damage and show the amount of deduction for each item. If the damages require a contractor to come make repairs, the landlord has to put that in writing by the deadline. He then has another 15 days to provide the costs of repair. What do I do if my landlord doesn't send a refund or a letter within the time limit? Start by sending a letter to the landlord to ask for the refund. Send delivery confirmation or certified mail, and a copy by first-class mail. You can also text or email. Make sure you keep a copy so that you can say you tried to solve the problem before going to court. Your letter to the landlord asking about the refund should include your name, the address of the property, the date that you gave the landlord notice you would be leaving, the date that you actually left the rental unit, and an address where the landlord can send your deposit refund. What if my landlord still won't return my deposit? If your landlord doesn't refund the deposit after a reasonable time, you can sue the landlord yourself in magistrate court or talk to an attorney about taking your case. Remember that in a court case, both sides can bring up claims. Your landlord could sue you back for any money that you owe. Legal Aid of West Virginia has resources that might be able to help you with your security deposit issue. Please contact us for more information.